Hello, this is Rick Cunningham with Cunningham Law. Today, I would like to talk about the top 5 mistakes people make on buy-sell agreements. But first, let me talk a little bit about myself and Cunningham Law. I have been an attorney for 21 years starting this year. I have an advanced degree in taxation, which means I took an additional year of law school focusing on tax. This allows me to help with estate planning matters and tax matters, as well as business law. Before I became an attorney, I also was a banker. So I have a lot of information and experience on the secure transactions and the business side of transactions as well. Now let's talk about the 5 mistakes for buy-sell agreements. Mistake number 5 is not having a buy-sell agreement in place, or relying on the default buy-sell agreement in an operating agreement if you have a limited liability company. Why is that a mistake? Well, the problem is that each business is unique, and each business and each partners may have different needs. And if you rely upon the default ones, that may not be what you need. So you should have a discussion with your business law attorney on what is the appropriate buy-sell agreement to have. Many times when we're forming an entity, the clients will say, I don't want to deal with a buy-sell agreement right now. Let's just get the entity formed. And we do that. But then what happens is if you don't have that buy-sell agreement in place, later on when an event occurs, you wish you would have had it in place. So the first thing to do is to make sure you have a buy-sell agreement in place and it has the terms that you want. The 4th mistake here is that when you tie your business agreement to participation or investment, you need to make sure that the buy-sell agreement follows those terms. For example, you may want to have a partner be in the business for 5 years. If they leave the business sooner and they trigger the buy-sell agreement, they shouldn't be getting the full value of their membership interest because they didn't meet the terms the full 5 years. So for example, in year 2, they left, maybe it's a 40% discount on the value, or maybe it's a 30% discount. Each discount is unique to your specific situation, but it's important to tie those investments and participations to the buy-sell agreement. Otherwise, the company or the other partner could be paying more money and not realizing what the value that they've agreed upon. The 3rd mistake that usually happens is either you don't address disability or you don't have disability insurance. There are times where it may just be too difficult to decide whether you need to address disability, but it is a discussion that you should look at. Because what if one of the main partners and owners becomes disabled and cannot work? You need to be able to have some way to be able to pay them, but maybe it's not the same value. Maybe there's a way that you use some of that disability for them to still have a source of income, or maybe there's a way that you could trigger it to be able to pay for the key man or for someone else to step in. It's an important discussion to have, not only with your business attorney, but with your insurance agent. The 2nd mistake for buy-sell agreements is not funding the agreement or allowing the time for payments to be made. So let's start with the first one of not funding the agreement. How do you fund a buy-sell agreement? Well, many times that's by having life insurance. So if someone passes away, you have the ability to pay their estate or their trust the value of the ownership interest. If you don't make those payments or don't have that ability to fund it, then what happens is usually the company has to pay for it. And maybe the company doesn't have the ability or the funds at that time to pay the full fair market value of the ownership interest of the deceased shareholder. The 2nd component of this 2nd mistake is a lot of times they just say you have to make the payments. Well, what happens is you may not be able to make the full payment. So maybe you want to have a promissory note and may have it secured by those ownership interests, and you make payments over time. Those things need to be discussed. So it's a good thing to do is to talk with your attorney to figure out what's the best way to do so. And finally, one of the most important mistakes, or the number 1 mistake, is that you value your business at a fixed amount. I can't tell you how many times I've seen a buy-sell agreement that the company is worth X. Well, that was 10 years ago. The company may be worth Y, which is substantially more than X, but because the two of you have an agreement that says that the value is X and you get 49% of X upon a buy-sell agreement, that may be enforceable. What may occur is that maybe have some litigation or other things like that in place. So what we recommend is either having some sort of formula, or if you insist on having a fixed amount, that fixed amount is amended at least on a yearly basis. If you would like to have some more questions or some help on buy-sell agreements, I would love to talk with you about that. Just reach out to us and we'd love to help you. Thank you and have a good day.